I'm David Todd, and I'm an eminent domain and condemnation attorney in Texas. If your land is going to be affected by a public project, here's the things that you need to know to protect yourself and your property. People contact me and say, how can this happen? How can they take my property? Eminent domain is the power of the government to take property, your private property, for their public project. That can be power lines, that can be roads, that can be water lines, that can be also oil and gas pipelines where a private company can borrow the government's power of eminent domain to take your private property. What is condemnation? Condemnation is the legal process where the government or a corporation that's using eminent domain exercises that power of eminent domain to take your private property for their public project. What is a condemnor? A condemnor is simply the entity, whether the government or a private company, that's using eminent domain authority and the condemnation process to take your property for their project. So what are the steps in the condemnation process when your property is being taken for a public project? First, there's going to be notice and appraisal. What does that mean? You'll get a letter, you'll get a phone call, you're going to get notice of this project that's coming that's going to affect your property. At some point, you have to be sent by the condemnor, the condemning authority who's building the project, an offer packet. And that's key because in that packet, there's going to be an appraisal that they've done. They're going to have the actual offer, money offer written down, and a lot of other details that'll be helpful in evaluating exactly where they're going to go on your property and what they're going to do, including a survey that shows exactly where the property is going to be intersected or taken for this project. Once you have that, you can evaluate a lot better exactly what's happening to you. Before you get that packet, you really don't have all the details. So it's important usually to wait until you get that packet so then you can share it with an attorney if you're talking to an attorney, or even if you're trying to handle it yourself so you really know what they're talking about. And it's usually a mistake to try to settle before you get that packet. The condemning authority, whoever's building the project, would like to try to settle with you up front before having to give you the packet and certainly before filing a lawsuit. But if they can't settle with you, they will file the condemnation lawsuit. It's a civil lawsuit, you'll get served with it, and that starts the legal process of condemnation to exercise the eminent domain authority to take your property. Once the lawsuit is filed by the project builder, everything stops as far as courthouse stuff until you go to what's called a special commissioner's hearing. What is that? Well, the court will appoint special commissioners to listen as a sort of judge panel in an administrative type hearing, a mini trial, if you will. They'll listen to the appraisers for both sides, any experts for both sides. They'll listen to the landowner about values for their property. And at the end of that hearing, which usually takes a half a day or a day, sometimes longer, they will come up with a number, and the commissioners will file that number with the court. What is the meaning of that number? Once that number's been filed with the court, and once the project builder puts that amount of money with the registry of the court, the project builder is allowed to take your property and start construction at that point. The other part of that is, though, that either side, the project builder or you as the landowner, if you're not happy with the number the commissioners came up with, you can file an objection with the court, and that number, you basically get a do-over. That's not the final payment number. They can still take your property and start construction once they deposit the money, but you can go ahead and litigate in court to determine, either with a judge or with a jury, deciding what the actual payment should be for you. If you choose to go beyond the special commissioner's hearing, file an objection, and choose to go to litigation, there's one more step you'll have to go through, which is called mediation. Basically, every court in Texas will require you to go to a voluntary mediation process, which usually lasts about a day, to see if there's a chance of resolving the case voluntarily by agreement between the parties. The mediator doesn't have any authority to force you to do anything, but they are there to try to help you get it resolved. If you get it resolved there, the case ends there and it's settled. If you don't, you can continue on to trial. And like with any trial, at the end of the trial, if there's a problem, a legal problem, and somebody feels like they have a basis for an appeal, there could be an appeal of that judgment or verdict, which could lengthen the process more until you get a final result. How long does the condemnation process take? It can take anywhere from a few months to several years, depending on how far down the road you go, whether you go through litigation, how much work is involved in getting it resolved. So it just kind of depends, but it can be several months to several years. How do you know if a public project is going to affect your property? Well, first of all, you can contact the project builder. A lot of times there will be a public meeting announced, or there's online information about a particular project, and you can also call either the right-of-way company or the governmental entity or the corporation that's doing the project and find out as much as you can about where the route is going and whether you're going to be affected. When, for example, a pipeline company files for permission to build a pipeline, they have to file the proposed route. So that data is actually out there to show where they're going to come through. The other answer to this is when you get the formal offer packet that they have to send you before they do anything to your property, you will have a survey that shows exactly where they're coming through your property. The other way to do it, of course, is to talk to an eminent domain attorney where they can hopefully look at the database and help you figure out if you're actually going to be impacted by this, or they can contact the company for you and help you work that out and make sure what's going to happen to your property. If you've heard about a project or you've been contacted by an attorney or someone else regarding a project, you may be wondering, well, why have I not been contacted by the project itself? Why have I not heard anything from the project builder if my land is going to be affected? Well, a lot of these projects are announced years in advance. So there may be meetings about it, there may be environmental studies, there may be permitting processes going on that take a long time in some cases. That's part of the frustration sometimes for landowners. But it's a good idea to take the time to find out if you're going to be impacted, because the sooner you can get some help, get more information, learn how this process works, the better prepared you're going to be when you finally get that offer packet and they really start to move quickly on taking your property. Does the project builder have to tell you what they're going to do to your land? The answer is yes. Under the Texas Property Code, there's a certain procedure the project builder has to follow, including giving you an offer packet that's going to lay out how much they want to pay you, how they got that number, exactly where they're going to come through, what the terms of the deed for coming through are, all those kind of things. So you will be informed at some point of all the details of exactly what they're going to do to your property. Can you stop the condemning authority, the project builder, from taking your property for their project? The answer in almost every case is no. Can you make the project builder change the route where they're coming across your property? In most cases, the answer is no. However, if you talk to them early in the process, sometimes road builders, people doing pipelines are open to usually minor changes in route if it makes sense for them, makes sense for the landowner. So it's worth at least talking to them early in the process about any requested changes to route that you want to suggest. Do they have to pay you when they're going to take your property for a public project? The answer is yes. You usually cannot stop the eminent domain process, but what you can do is insist that you're paid fully and fairly. They do have to pay you. The U.S. Constitution and the Texas Constitution say so, and you're supposed to receive full, fair compensation for what's going to be done to your property that's going to change it forever. Will the offer that you receive be fair? The answer in most cases is no. And there's a reason for that. Most of these projects are acquiring multiple properties, and whoever the project builder is, whether it's a corporation, whether it's a government entity, they want to get your property and all these other properties as quickly and as cheaply as possible. They know that a certain number of landowners will take the initial offer, as low as it may be. They also know that a certain number of landowners are going to say, wait a minute, this is not fair, this is not full compensation, and they are going to say no until the other side does the right thing. They also know that a certain number of landowners are going to get legal help and expert help to really make sure that they're getting full, fair compensation. And they plan for that. It's a little bit like when you're injured in a car accident. The insurance company knows a certain number of people are going to take that first lowball offer that gets sent to them to just try to get it done and get it off their books. They also know a certain number of people are going to say, this is not right, I'm going to get help. It may take some time, it's going to take some work, but I'm going to be treated fairly, and I want to make sure that I'm fully compensated for what's happening to me. You have to have that same approach if you want to get the best result for your eminent domain case. So the project builder has contacted you about taking your property for their project. What should you do? Well, it's fine to talk to them and get details. It's fine to discuss. It's fine to meet with them. And it's fine to allow them to come onto your property to do a survey. In fact, if you refuse, they're going to go to the court and they're going to get permission to come on your property anyway. So it's usually a good idea to just work with them, let them get the survey done so they can get the offer packet to you. That's where you get the details. Very important not to do anything before that point. The other thing you want to do is talk to an eminent domain attorney. And obviously I'm biased on this, but it's a good idea to at least run your case by somebody that knows how this process works and what are your options. They may even want to reach out and talk to an appraiser or a land planner or an engineer if there's any other specific issues that come up about your property and your land use. But you want as much information as you can from people that know how this process works before you make any decisions that will affect your property forever. Can you handle this yourself? Yes, you can. One option, of course, is just take the offer that's probably low that they've sent you, or maybe something a little higher that you can negotiate. If you really want to get full compensation, you're going to have to probably testify as a landowner at a special commissioner's hearing, or maybe even on into trial. And it can't just be your opinion, it has to be based on something, some data. You have to have some evidence to back up your opinion of value. You can't just put a value on it because you say so. That won't work. It won't hold up. What does that mean? Obviously, I'm biased, but when you get expert help, you're almost always going to end up doing better, getting a better outcome, getting more compensation, even after paying the experts that help you in that process. It's also going to take a lot of the stress off your plate because you have a buffer between you and the folks taking your property, and it makes it a lot easier to figure out what's going on with people who've been through the process before. So you can do it yourself, but it is a lot more work and it's harder to get as good of a result. Remember that whoever is taking your property, whether it's a government entity, whether it's a corporation doing a pipeline or something like that, they're going to have plenty of money. They're going to have plenty of legal help. They're going to have appraisers, engineers, land planners, whatever they need to justify whatever low number they would like you to have to accept for what's going to happen to your property. The largest benefit of having expert help on your side is that you are a credible threat to, if necessary, take this process all the way through trial. Why is that important? Well, first of all, if you have to do that, if you have to go all the way through the process because they just won't do the right thing, you're ready, you're prepared, you have the help you need to do that process and hopefully get the best result you can. The other thing that happens is when you are ready, willing, and able to do that, better things tend to happen earlier in the process. You may get a better offer that allows you to settle it. You get a better result at the special commissioner's hearing, which you may be okay with, that result. At mediation, you do better if you've really got your evidence lined up and you're ready to roll if you have to go to trial. And of course, the trial process itself, you have to have help to get that done and do it right. So getting the right help early in the process tends to shorten the process and have a better result regardless of how long it takes. How much will you be paid when your property is going to be taken for an eminent domain project? There are 3 elements to the damages and how it's computed to figure out what's full and fair compensation. The first is the take itself. So if it's a full property take, if they're taking all your property, it's what is the full and fair value of that entire property. And that's usually a comps battle where you're looking at comparable sales properties and trying to figure out what's it really worth. But usually it's a partial take. So you're trying to figure out what is that strip of land or that portion of land that's being taken, what is that actually worth? The second part of damage compensation is what's called cost to cure. And that means anything that is broken or removed that has to be repaired or replaced. It could be buildings. Out in the country, it could be cattle guards, fences, lighting. It could be signage. It could be anything like that that you're entitled to compensation for. And the third thing is what's called damages to the remainder. What that means is if they take part of your property, what happens to the value of the rest of the property that you had before and that you'll have after? But because of this project happening, what's the change in the value in that? And sometimes that can be the largest number in damages depending on what's happening to your property. So those 3 elements are determined and put together to figure out what full and fair compensation is. And it's usually much higher than what the project builder wants you to believe. What will it cost you to use an attorney? Well, at our firm, it won't cost you anything up front. We do what's called a no-win, no-fee guarantee. What does that mean? The first number offer that you receive, we never take any portion of that. Our fee, if we can do better than that, is a portion of the extra money we get you above that initial offer. So if we don't do better, there's not a legal fee. And that's all laid out in a written agreement that we would do at the time of you deciding we want to work together on the case. Could there be any other costs involved? Yes, sometimes there'll be appraiser costs or land planner costs, but that depends on the individual property and the individual situation, and your eminent domain attorney should be able to help you figure that out. So why should you listen to me? Why should you consider using the Todd Law Firm to help you with your eminent domain case? First of all, we only do the landowner side. We never represent the project builder. We like to work for the folks that own the land, that are having this done to them against their will, and we really take a lot of pride and we enjoy helping those landowners get the best result they can out of what for many folks is a kind of a bad situation to start with. We do cases all over Texas. We specialize in commercial, industrial, special use, and also large tract rural type cases. So if you fall in that category, we're especially interested in talking to you about your property and how we can help you get the best result. What is the Todd Law Firm process? If you give us a call, you'll find out quickly that our approach to your case is going to be to prepare it from day one as if it's going to go to trial. The reason we do that is if you have to go to trial, which sometimes happens, you want to be ready. You also get better results in general earlier in the process if you're ready to go to trial if necessary. At negotiation, at a special commissioner's hearing, at mediation, anywhere along the line, if the other side knows that you have your evidence together and you're ready to go, they're usually willing to do the right thing sooner in the process rather than later. Check out our website, give us a call, let us give you a free case evaluation. We'll walk through your situation, how the property is going to be affected by this project, and what we can do to help you get the best result.